matter of Jazztel PLC and the Commissioners for Her Majesty's Revenue and Customs.
Mr. Krasinski.
Good morning, my lords. Before I go back to the section 32(1)(c issue, can I address you just on the case of Elias that my Lord Justice Singh mentioned yesterday, and its relevance to our argument that the ratio of Fleming is binding, even though Mr. Vida did not, for the Commissioners, include in his 4 different analyses of how one might limit the disapplication or not disapply Regulation 29(1)(a), the analogue of Section 320. He did not advance an argument precisely the same, based on precisely the same distinction as that advanced by Mr. Baldry. As my Lord Justice Singh will obviously recall, and as I will just briefly explain to the other members of the court, Elias was a judicial review challenge to the lawfulness of certain features of an ex gratia, not statutory ex gratia, compensation scheme to compensate British civilians who had been interned by the Japanese in World War II. The claimant, a Mrs. Diana Ellis, was a British citizen, and she had been interned by the Japanese in Hong Kong in World War II. However, she was not born in the United Kingdom. Her parents being Iraqi Jews. Her mother was an Iraqi Jew, her father was either an Iraqi or Indian Jew. There was a migration of Jews from Baghdad to India in the 19th century, by the by. For that reason, the absence of what was called a birth link, i.e. having been born in the United Kingdom, gave rise to her being refused compensation by the Secretary of State under the scheme. And in her claim for judicial review, in which she was represented by my Lord, she advanced the claim based upon unlawful discrimination, both direct and indirect, contrary to the Race Relations Act. And one can see that. I'm not going to spend much time taking you through the judgment, but just to identify it, handed up judgments just before you came in. If you just turn to page 3221 of the law report, 3221. Sorry to swig from a bottle. We don't get cups anymore.
No.
So you see there, Lord Justice Mummery, very briefly describing the main grounds. The main grounds of the challenge, main grounds of challenge, the lawfulness of the administrative action, are direct or indirect race discrimination contrary to the Race Relations Act as amended, and unlawful fettering of discretion. As my Lord Justice Singh also mentioned yesterday, there had been a previous challenge to the scheme, leading to a previous decision of the Court of Appeal on a JR case. We can see the nature of that challenge in Lord Justice Mummery's judgment on page 3224, particularly the Absifer case, the Association of British Civilian Internees case. And you can see at letter D on that page that the challenge was unsuccessfully argued that the birth link criteria were unlawful because they were disproportionate or irrational and defeated the legitimate expectation created by the terms of the enactment of the scheme.
I'm so sorry, which page are we on?
3224.
3222, thank you.
3222.
Sorry, I was 10 pages ahead. 3224, thank you.
So it's paragraph 21, just above letter
Sorry,
D.
I've got it now.
And then at paragraph 23, Lord Justice Mummery records, although exclusion on the grounds of race was not mentioned in that passage, that's a passage in the judgment of Lord Justice Dyson, or anywhere else in the judgment, it has now been conceded by the Secretary of State that the birth-link criteria were indirectly discriminatory. The Absifer case was argued and therefore decided on more conventional judicial review lines than this case. The anti-discrimination provisions in Article 14 CHR, which refer to discrimination on the grounds of race, were relied on in the context of an A1P1 argument. But there was no challenge to the lawfulness of the scheme under the 1976 Act. In our respectful submission, the differences between the Elias case and the Absifer case are nothing like the position in the present situation. In Fleming, the legal issue was precisely the same as it is in this case. Namely, was the new limitation period in accordance with EU law, in particular the principles of effectiveness and certainty, notwithstanding the absence of any transitional period, and if so, how should the new limitation period be disapplied to those with accrued rights? So as I say, the question being considered both in Fleming and in our case is fundamentally the same. And the fact that, and also the facts concerning the tail end of the Condé Nast claims are covered precisely, by analogy at least, cover the same facts as arise in our case. So in my respectful submission, the fact that Mr. Vida did not articulate a fifth proposition that mirrors the one that Mr. Baldry has now fixed upon does not render the ratio of Fleming anything other than binding. And indeed, if it did, that would be, if I may say so, a very large inroad into the doctrine of stare decisis.
Right. And the whole point of a ratio is you then have that binding principle which you have to apply to future actual situations.
Yes.
And unless one's able to say it was that principle was laid down per incuriam, the arguments which led to it are only indirectly relevant. It's helping to actually establish what the ratio is.
And Mr. Baldry very properly has not and could not argue that Fleming was decided per incuriam.
No.
Just to be clear, in terms of Elias,
Yes.
there had been the earlier challenge on different grounds.
Yes.
We don't get any more from the Court of Appeal about
No.
the relationship between the two. It's
No.
just part of the history.
It's part of it.
Yeah.
I hope that addresses my Lord's question to me yesterday. While I'm on the Section 320 issue, we've also considered overnight the ICI and Colmer decision and the decision in the International Council for Civil Liberties case. And while they, with respect, contain valuable guidance about the nature of the remedy of disapplying national law when it is found to be inconsistent with EU law rights, nothing in them is, in our respectful submission, contrary to the decision of the House of Lords in Fleming. And indeed, the judgment of my Lord Justice Singh in the latter case, the NCCL case, cited extensively from Fleming. And at the risk of stating the obvious, in the unlikely event that there were any inconsistency, notwithstanding the constitution of the court, the decision of the House of Lords would have to prevail over that of anything decided lower down. So that's all I want to say about those cases. And can I now turn back to the Section 32 issue. I identified yesterday the propositions that we say can be derived, should be derived from the judgments of the majority in FII. And I'm going to go back to the speeches, the judgments in FII soon. Before I do that, I want to, first of all, spend a little time on the first instance judgment here, to give what comes later some factual context. I'm then going to deal with the judgment of the House of Lords in AB and Ministry of Defence and some of the other cases upon which it's built. And then I'll go to FII. So, if we turn up the judgment, in this case, tab 9 of the core bundle, I'd like to start, if I may, with paragraph 68. Now, I beg your pardon. I'd like to start earlier than that, paragraph 62. This is after the judge has set out the documents, and then this is his analysis. Period 1. Well, period 1 covers the period up to the Linklater's advice of December 99. During the course of period 1, which culminated in the publication of the prospectus for the IPO. That just to give you the date, the prospectus is the 8th of December 1999. You can get that from paragraph 46 of the judgment. There can be no doubt that Jazztel considered it was liable to pay SDRT. That is what Jazztel was repeatedly told by Linklaters in terms that were unqualified. And that is what it told investors in the prospectus for the IPO. That's a public document, obviously. During this period, there were communications between Linklaters and the revenue, pursuant to which Linklaters sought confirmation that the share issue, as from time to time structured, because there was an evolution in how it was to be structured and where the shares were to be listed. It was originally contemplated they would be listed on the Spanish stock exchange, and then it came to be decided that they would be listed on the IASDAQ, which was the Brussels-based European equivalent of the NASDAQ. That's all, again, set out in the judgment. Would attract SDRT. There was no suggestion at this stage that the tax might be unlawful or susceptible of legal challenge by either Linklaters or HMRC. I conclude that as at the end of period 1, Jazztel's corporate state of mind was that the liability to pay SDRT was a lawful one, and that although Jazztel was not the person in law liable to pay the tax, there was an obligation on Jazztel that it had to assume. The communications that occurred during the course of period 2 covers the Linklater's advice and the letter to the revenue in January of the following year, qualified as state of mind. Essentially, Linklaters wrote the December advice. That communication, including its attachment, which was the Fuller memorandum, was noted and taken on board by Jazztel because Linklaters thereafter began communicating with the revenue about Jazztel's liability to pay. I find that Linklaters wouldn't have communicated in these terms with the revenue without instructions from Jazztel, which I therefore infer took place. Jazztel was therefore plainly aware of the advice it had been given and modified its position as a result, but it still paid SDRT, albeit under a reservation. And then this critical paragraph, in my judgment, Jazztel's predominant state of mind after the 22nd of December advice remained that the liability to pay SDRT was a lawful one, and although it was not the person liable to pay, this was an obligation it had to assume. That's why the payments were made. I accept that the advice must have injected an element of doubt into what was Jazztel's state of mind prior to this communication, which was an unqualified belief. In short, the monolithic state of the belief came to be qualified, but did not otherwise change or crumble. My reasons for reaching this conclusion are as follows. The December advice amounted to no more than a responsible solicitor identifying to his client a potential argument that might be taken, which, if successful, might result in the SDRT being found to be unlawful under community law. It was precisely the sort of big picture advice that a client would expect before paying over a significant sum of money. And I just pause there. I'll come back to this point when we discuss the relevance of the test of seeking advice or commencing investigations. And there's a valuable part of the speech of Lord Wilson and AB that deals with this. But the point I'm going to make is that there was no finding by the judge, no evidence, that Jazztel asked for the advice from Linklaters. And we'll see the relevance of that later on, just to foreshadow it. Sometimes going to see a solicitor is indicative that you think you've got a claim that's worthwhile pursuing. To take an obvious example, and I know it's at the extreme end of the spectrum, you're knocked over on the pedestrian crossing. You know something must be wrong. Someone is to blame. Well, the driver is to blame. You may never have heard of the law of tort or the concept of negligence, but you go and see a solicitor, and the fact that you go and see a solicitor indicates strongly that you think you have a worthwhile claim pursuing, but it's still focusing on the state of your mind. Do you think you have a worthwhile claim that's worth pursuing? But then reading on, the December advice was neither substantive, nor conclusive, nor robust. This is no criticism. The point of the advice was not to be substantive, conclusive, or robust, but to identify to Jazztel a potential issue and the manner in which that issue might be approached. The advice was less about Jazztel's present legal position, brackets, you are not liable to pay this tax and you should challenge it. Those obviously aren't words quoted from anywhere. That's the hypothetical alternative that was not being said. And it was more an attempt to identify potential future courses of action for Jazztel to take in light of the point that had been identified. If you or someone else were minded to challenge the tax, that challenge might succeed, in which case there are certain steps you can take to protect your position. There were two options: do nothing or pay and seek further legal advice. In the event, Jazztel followed neither course, but took a middle way. Payment was made under a reservation of rights. Linklaters pressed the argument that SDRT was an unlawful tax, but Linklaters didn't press very hard. And once HMRC stuck to its guns in a document that we've looked at, and I'll show you again briefly, Jazztel dropped the matter. This is a real quote. Our client is not, at present, proceeding with this matter any further. Jazztel certainly did not go any further than this and seek specialist counsel's advice as to whether the SDRT would successfully be challenged. So again, just to foreshadow what I'm going to say when we look at the authorities, this is not a situation in which the judge has found Jazztel was given some advice that there might be a possibility here. And it thought to itself, well, I believe I've got a worthwhile claim, I better pursue it. They've approached me with unsolicited solicitor's advice. Now that I've got it, I think I've got a worthwhile claim, at least to the extent of knowing I ought to pursue it by seeking counsel's advice or instructing Linklaters to spend a bit of more time and money looking at what should be done. Paragraph Roman 4. In these circumstances, there are two possibilities. A, Jazztel's state of mind continued to be that SDRT was due and payable, despite the advice, despite, in short, its state of mind remained predominantly as I've described in paragraph 64, or the advice so affected Jazztel's corporate state of mind that the state of mind was overwhelmed by the new information, such that Jazztel's predominant state of mind was that SDRT was not due, or that Jazztel was prepared to take the risk of paying SDRT, where its predominant view was that the tax might not be due. That was the argument being advanced perfectly properly, but unsuccessfully, by Mr. Baldry. Whilst I consider that Jazztel must have had some doubt as to whether the tax was lawfully due, my conclusion is that this doubt was a marginal one, and that Jazztel's state of mind was predominantly as it had been prior to the December advice, namely that the tax was due.
Just pausing there.
Yes.
In terms of the judge's two possibilities,
Yes.
he has in mind, presumably what he said back at paragraph 30, subparagraph 2.
About the balance.
Which is all, you can still be labouring under the mistake
Yes.
if you think it's more likely than not to be due. So that's 49%.
Yes.
But in after he set out the two possibilities, he seems to go further.
And he's going to go even further.
He says
still
the doubt was a marginal one.
And I'm going to show you another passage in the next subparagraph where he characterises the nature of the doubt in a even more granular and we say helpful way.
Yeah.
As I have said, I'm now reading from the last sentence on page 130. As I have said, prior to the December advice, the advice to Jazztel had been that the tax was payable, and this was Jazztel's corporate view. Jazztel's public position, as stated in the IPO prospectus, was that the tax was due. The December advice was not conclusive and didn't purport to be. It was received only very shortly before the first substantial payment was due. That's the £1.8 million. I don't consider that an organisation like Jazztel would so fundamentally alter its view as to its liability simply on the basis of such a communication without obtaining further legal advice so as to establish greater certainty. The fact that Jazztel did not request further advice strongly suggests that Jazztel's state of mind regarding the liability had not changed. Again, no challenge to that finding. During the course of period 3, Jazztel received further notifications from Linklaters that the tax was due and it paid it, sometimes without any reservation of rights. And as we'll see, there was no reservation of rights from 2002 to 2006. Sometimes post-2006 with a reservation, but that is all Jazztel did. To my mind, this indicates not an indifference as to whether the tax was payable, but a firm view that the tax was due. Had Jazztel harboured serious doubts about the liability to pay, it would have, I had said, take further advice. So what the judge is saying there, and this is what I mentioned to my Lord Justice Newey before, is they had no serious doubt that the tax was due. And I'm going to be submitting, and then we'll submit now, that you cannot meet the standard of believing you have a worthwhile claim if you have no serious doubt that the tax is due. And then Romans 6. Essentially, Jazztel was prepared to play the angles if Linklater's suggestion, and that's how I would characterise the December advice, that SDRT could successfully be challenged came to pass. Jazztel wanted to do what it could to protect its future position, provided the cost was de minimis. Thus, it was quite prepared to have Linklater's right and to qualify its payments and to suggest to HMRC that the tax was not lawful. And whether my Lord think that was a correct letter for Linklaters to write or not is, with respect, nothing to the point. It's nothing to the point because you can't imprint Jazztel with a belief in what Linklaters have said to the revenue, and indeed to do so would be completely contradictory to the judge's findings of fact.
Well, that may be right, but can we not infer that Linklater sent it on instructions?
Can infer that Linklater sent it on instruction.
So why doesn't that give us some assistance as to what Jazztel's state of mind was?
But if this was a trial, my Lord, that might be a point that Mr. Baldry could take. Indeed, he did take much the same point below. But the judge's finding...
No, I understand that. Yeah, I understand your fundamental... Sorry, Mr. Baldry.
We would rely on paragraph 65 too for the finding that the judge did find that they instructed Linklaters to write the advice.
Yeah.
No, I don't dispute that.
I understand your submission, Mr. Krasinski, that when it comes to the subjectively
Yes.
of FII, that the findings of fact made by the trial judge are conclusive against the revenue and there has been no appeal against them. I understand that.
Yes.
But I just want to clarify one thing about the letter
Yes.
of the 11th of January. First of all, I have to say, I note that although the judge at page 130, sub-Roman 3, refers back to that correspondence,
Yes.
the way he characterises it there is simply to say Linklaters pressed the argument.
Yes. And then he comes back to it again in
Forgive me,
Romans 6.
yeah, I know. The primary evidence is what's at page 123, which is the letter
Yes.
quoted. At least as it seems to me, and this may not be something that we can do anything about, or should do anything about, because as you say, there's no appeal on this point, but at least as it seems to me, the point he doesn't really attach any weight to is that Linklaters were not simply advising, they were not simply pressing an argument, they were actually asserting on behalf of their client that the revenue had a legal obligation to pay the money back.
My lord, I accept all of that, but for 3 reasons it can't provide the answer to this case, possibly 4 reasons. First reason is the one that you've already identified, which is that it cannot affect the ultimate conclusion on Jazztel's state of mind because there's the unchallenged finding on that. The second point, which I think my lord was also adverting to, is whether it could be evidence of what could reasonably have been discovered.
No.
Object. No?
No. At the moment, we're only dealing with subjective. Yeah.
Well,
and you say the answer is it's a finding of fact, tough if you didn't appeal against it.
that is.
I understand that. Yeah. But I do want to, because it may be relevant to, as you say, when you move on to the objective criteria, which you haven't got onto yet, it could have relevance to that.
Well, I'll deal with that in due course.
Yeah.
But and I know that this was a submission I made yesterday, and whether it falls on stony ground or not, I'll repeat it. In the real world, solicitors will write letters to counterparties asserting claims in confident terms. They do not write saying, I think you may have knocked me over, but I'm not sure. My recollection is fuzzy. Or I think I may have made a mistake of law, but actually I don't really believe in that. This isn't a trial, and wouldn't have been a trial, of Linklater's professionalism or of Jazztel's bona fides in inviting Linklaters or instructing Linklaters to write the letter. So I don't, with respect, accept my lord's suggestion that the letter properly informs Jazztel, a conclusion as to Jazztel's state of mind. It's their solicitor doing their best for their client. It does not mirror legally privileged advice that was given a few days earlier in much more qualified terms. It's that advice that the judge rightly focused upon as being imputed to Jazztel. If you get legally privileged advice, solicitors all the time write advice saying, well, you've got to, I don't need to tell my lords, this is the situation. You've got all sorts of legal arguments. We don't think they'll succeed. It may be worth writing a letter to see whether the other side will pay. Whether that's right or wrong, whether solicitors should do that or shouldn't do that, that's what happens. And you can't impute from the assertions in that letter the client's belief that they believe that to be the case.
I suppose, in terms of Linklater's letter, there's a very good grounds bit. And do you say, well, forget about that? You can't infer from the fact that the Linklaters said there were very good grounds that Jazztel thought there were very good grounds. What you do get from the letter is a fleshed out version of the attack.
I accept that. And then you get the letter that I'll show you in a minute from the revenue saying why there isn't an attack and why the season ticket answer is the answer. And I'll show you the passage in the Court of Justice's judgment in HSBC, I think it's paragraph 32, where they record the United Kingdom's argument being the season ticket argument, which was supported, as I mentioned yesterday, by the European Commission. And then you get the evidence that Linklaters are being instructed not to pursue the matter any further. Not, we're being instructed to investigate this further, we'll come back to you.
Yeah.
But equally, the claim wasn't withdrawn, was it? And it remained on the table as sent as an assertion of a strongly arguable and said to be correct legal argument that the primary legislation was unlawful.
My lord, again, in the real world, solicitors don't write back to the revenue months later saying, well, we wrote to you a few months ago saying we might have an argument, and we know we've written to you since saying we're dropping it. But by the way, we ought to inform you that we don't think we had a good argument in the first place.
Well, I know, and I'm not trying to lead in, but I'm just, well, as I said yesterday, I'm still troubled by, although I accept fully your point that, of course, one has to have regard to the realities of litigation and the way solicitors and clients normally behave and how they're understood by their correspondent, by the people they're corresponding with, to behave. But we are in a high-profile area here, where an assertion is being made, as I say, that unambiguous-looking primary legislation is actually overridden by community law to such an extent that this tax was not due and payable. And I mean, solicitors shouldn't write letters like that, without thinking are on strong ground, it seems to me.
Linklaters is not. I'm not here to.
No.
Bad for business, but I'm not here to defend Linklaters.
I know you're not.
And
But
Linklaters
equally,
isn't
the
here
letter-
to defend itself.
But the letter was sent on instructions, so the text must have,
I don't dispute
the
that.
letter must have been approved
Yes.
by the clients.
And it must have been approved by the clients. But again, my clients' ethics, and again, this is not to say anything against it. They're not on trial here.
Yeah, and I hasten to add, I'm not casting any aspersions on Linklaters specifically. I'm just worried about the way perhaps this point didn't get the attention it merited before the judge. But then your answer to that is there's no appeal about it.
And that, with respect, is a complete answer.
Well, that may well be right. But,
And in case that anyone's in any doubt, I want to echo what my lord has said, that I'm not casting any aspersions on anyone. And certainly not Linklaters, who are not, as you say here, to defend themselves. But to foreshadow a point that I know you're going to return to later, it may be said that it does have some relevance to the objective limb of the test.
Just to anticipate that, I would, with respect, can I come back to that?
Of course.
I'm going to illustrate the differences
Absolutely.
between. So, just picking up finally paragraph 68, Roman numeral 7. Jazztel's approaching period 4, after the delivery of the AGO's opinion, is instructed. It notified the charge to tax, but it did not pay, no doubt running a risk of penalties if it was wrong. At that stage, I consider Jazztel doubted that the tax was lawfully due, but not before. And as I've said yesterday, and we'll come back to, many of the other High Court claims in restitution in this GLO were issued after the AGO. None was issued before.
So it's a matter of the judge's findings. He has in effect found that at no stage did Jazztel have serious doubts.
Correct.
And moreover, he's arrived at that conclusion really as a matter of construction and inference of the documents because he had no live evidence. So the material that might be relied on to establish the objective limb is exactly the same material that persuaded the judge that Jazztel had no serious doubts.
The material that...
The material that might be relied on to show
Did you say the objective or the subjective limb?
the objective limb is exactly the same material. I mean, Mr. Baldry relies on these documents to establish the objective limb.
Yes, I still, with respect, struggle to understand how they can go to in a way that helps him, the objective limb.
And what I'm just putting forward is whether or not you say he can do it. He relies on those documents
Yes.
to establish objective discoverability.
Yes.
Those very same documents, and no more, are what the judge considered and led him to believe that Jazztel had no serious doubt.
Precisely so. Can I very briefly take you to a handful of the documents in the unagreed book? Starting with what we've looked at already at tab 40.
40.
40. So this is David Halsey deputy director policy in the Stamp Office, saying, we don't accept your arguments. Mr. Baldry below, in a passage recorded by the judge, said this wasn't a blockbuster answer, but it was essentially the answer that the United Kingdom government stuck to at all times.
I have to say, it doesn't strike me as a blockbuster answer. I mean, the answer given is simply paragraph 2, isn't it?
And paragraph 3. Next, you argue that...
Well, yeah, quite. But that's the answer to the freedom of the freedoms argument. The argument on the only answer on the Capital Duties Directive is Article 12.
Which is the argument that...
Which is the argument that was
I mean, that is
advanced.
the argument that was advanced by the government.
I quite follow that, but it isn't an obviously correct argument. I mean, the Court of Justice obviously didn't accept it. But on the face of it, this Article 12 is referring to transfers rather than issue.
If we're talking about what is reasonably discoverable, and you're in March 2000 and you're Jazztel, you've been told by your solicitors that there's a possible argument with weaknesses. You've been told that one of the weaknesses is the season ticket argument. Lo and behold, the deputy director of the Stamp Office comes back and says it's the season ticket defence. There is no litigation pending at this stage anywhere, either that you know about or frankly at all, which suggests that SDRT, which is I mean, we mustn't forget this is primary UK legislation, and we're still in the foothills of the EU law challenges in any other context, and I'm going to come back to that in a minute. So the idea that you should be saying to yourself, well, actually, I have a worthwhile, this is what would a reasonably diligent person have discovered? And we've got, as I said, no evidence. There's no evidence, for example, that Clifford Chance and Freshfields and other leading tax firms or any of the big four were at this stage advising their clients, we've spotted a really good argument here. We suggest you don't pay, or that if you have paid, you start reclaiming. And as I said before, if I'm going to be put down on the objective test, that would, when it wasn't, I mean, you mustn't lose sight of the fact that this is a defence being added to a pleading years after a trial. I mean, on the face of it, that is an astonishingly ambitious procedural step for any party to take, and normally would be refused. HMRC could have run this defence, we could have adduced evidence, we would have adduced evidence. For them to say now we should lose on the objective limb, just because there's one letter from Linklaters, which is then batted back, whether in blockbuster terms or cinema noir terms, is with respect neither here nor there. It would be astonishingly unfair, and I use those words advisedly, for my client to be put down on a defence that wasn't pleaded at trial, had no opportunity to adduce evidence at trial, even though the revenue could have raised it. So that's the letter.
Sorry, just one tiny point before I forget it. Could somebody tell us or remind us when SDRT was introduced? It was quite a relatively new tax, wasn't it then?
Well, it's in the Finance Act 1986. I don't think
Thank
that was a consolidating statute.
No, well, it was all to do with the abolition of stamp duty.
It was.
Yes.
As Mr. Jones says, and I'm taking it on trust, it was to do with the financial Big Bang.
Yeah, thank you.
Mr. Grzycki, I'm sorry to go back to it, but just want to be absolutely clear what your submission is about the status of the letter from Linklaters of the 11th of January, which is tab 33.
Yes.
I don't want to put words in your mouth. I really want to know how you characterise this letter. Could it be said to be something like a letter before claim, or is it in fact a claim? In other words, a claim, you, the revenue, must repay this money.
Well, I accept, my lord, that under the regulations, the SDRT regulations, there is no requirement of formality at all. So we are in a very different situation from the kinds of claims that are referred to in the case law to be accompanied by statements of truth verified with a signature. I would characterise it as a request to pay, written on instructions. But I would also, with respect, adopt, as I'm entitled to, the judge's characterization of what was going on here in his judgment, from which there has been no appeal, at paragraph 68, Roman numeral 6. Jazztel was prepared to play the angles. That's his language, not mine. It wanted to do what it could to protect its position, provided that the cost was de minimis, and it was prepared to have Linklaters write and to qualify its payments, and to suggest to HMRC that the tax was not lawful. That's what it was doing. It was making a suggestion. It was saying, can we have our money back? I accept that was a request for payment. It's certainly not a claim in the ordinary writ sense.
No.
Not that I suspect this matters, but in the event, this was a sufficient claim to allow you to get your money back.
Years later.
Years later, but I mean, it was effective as a claim, such that you were able to get your money back.
Because of the lack of formality
Yes.
of in the regulations.
So this is the only claim that was ever put in. Is that right? I mean,
No, there were claims put in much later on. But in this timeline, in the timeline that we're looking at up to 2009, I think this was the only time that the revenue said, we're paying, please can we have our money back?
yeah.
I mean, let's not forget, this is a letter written a handful of days after they've sent the cheque. You don't normally write a letter saying, here's a cheque, but it's not really due, can we have the money back?
See, one thing I haven't followed is, we know you got this money back. We know you didn't reserve your rights again, I think, for a number of years. So with all your subsequent payments, you didn't get that money back.
Can I just pause for a second?
We get the schedule at page 107.
Yes, it's page 107. I think I'd have to give you a particularised list if my lord wanted, but I think we got some of it back, but not others. But if you want a list, I can give it to you.
And I don't think it really matters, but I'm just sort of interested to understand. I quite follow. You got the initial payment back because you'd written the letter of request.
Yes, but in,
I
think sometime in the mid-2010s, we wrote a letter saying, please can we have the money back again?
Yes, but you might have thought that that would have been out of time.
Sorry, I'm just. So I'm helpfully told that most of the what are called issue 9B payments, which we lost on in front of the judge on the section 320 issue, namely items 10 to 23, we got back on an in-time statutory claim.
Yes.
Of the 9A payments, namely items 1 to 9, we only got back, I think it's sometime in back end of 2014, we got back to 1.8 million.
I follow. So with 10 onwards, you had made much later a claim in time.
Yes.
With 2, you got it back because of this letter.
Yes.
The others you couldn't get back because you hadn't claimed in time.
Yes. Does that answer my lord's question? I don't want to move on unless
Well, I just want to be absolutely clear about this. You've expressed it a number of times. You've paraphrased the letter. And I don't want to be unfair at all, which is why I'm giving you the opportunity to tell me in your words how you characterise this letter. You've a number of times said that it's a letter saying, please pay the money. You've described it as a request. And that may be right. But on the face of it, it appears to be slightly stronger than that. It appears to be an assertion by the citizen to the state that you have a legal obligation to pay me this money. not as it were a request that you should do so in the exercise of a discretion or something of that sort.
Sorry, my lord. I'm not sure, my lord, I can assist further in how I would characterise this letter. What its evidential relevance might have been on a trial of this issue had the issue been before the court is a different matter.
Yeah.
Well, it says what it says. I mean, really, we just have to interpret
It says what it says.
Insofar as it's open to us to do so in light of the judge's findings.
Precisely. So, again, and I know my lords have the point, notwithstanding this letter, the judge's finding is Jazztel had no serious doubt. Whether the letter should have been written in that circumstance is neither here nor there.
That's on the subjective.
Yes.
Yeah,
and on the objective, my lord has the point.
Yeah, you have your fundamental submission that we shouldn't be going anywhere near that.
Either permission should be refused, the point could have been taken and wasn't, which is the usual test, or, insofar as the point is allowed to be taken, because there needs to be further findings on what the objective test would have led to, I would strongly resist the conclusion that that letter alone can be indicative, and the matter should be remitted. Not with any great enthusiasm on our part. We'd rather the matter was brought to a conclusion favourably to us, obviously.
Well, it wouldn't have to be remitted. And we could take the position that, yes, the argument should be allowed to be run, but there's an insuperable objection to it, which is that given the very late stage at which the question has arisen, the only fair and just way of resolving the issue would be by way of a retrial on the objective limb. And that is not something which we should permit because of the normal principle that you don't remit matters, or you don't allow a new point to be taken in a situation where the evidence would have been different at trial.
That is, with respect, my primary position. My primary position is we win on the subjective.
Yes.
And this is what we said in our skeleton.
Yeah.
We win on the subjective test because of the insuperable and unchallenged findings of fact.
Yeah.
The objective test would require a remittal. A remittal should not be allowed because of the reasons my lord has just summarised. So our fallback position is if a remittal has to be allowed, so be it. But we can't be put down on objective on the basis of this one letter.
Yeah. Right.
So yes, absolutely. Our primary position is, and this is not adventitious. If that's the right way of putting it. Anyway, it's the ordinary principle. Why should the state be in a better position than an ordinary litigant when it could have taken a point? It did indeed take other points on which it, at that stage, were closed to it in law, the change of position defence, calling expert evidence and evidence of fact. But it didn't do this. We've had no explanation from Mr. Baldry, even though he took this point in our skeleton, as to why they couldn't have run it. We don't know when the new point first occurred to them.
Well, I mean, speaking for myself, it seems perhaps a bit unrealistic to suggest that the revenue should have run the point in 2017, which is a considerable time before the Supreme Court clarified the law to put it politely last year.
Is it realistic to say that years before the Advocate General's opinion, we should have run a mistake
well, all right, but that's why, I mean, perhaps if we do go down this route, my preferred way of looking at it would be to say it's a reason why this court, in the exercise of well-established principles, shouldn't allow the point to be taken in this particular case.
Yes.
I mean, it's a one-off point relates to this case. It doesn't prejudice the revenue more generally. Of course, they have the new guidance given by the Supreme Court. They can and will apply hereafter.
Precisely so.
But it shouldn't. We shouldn't allow an unfairness in the present case to be perpetrated if that is what would be the result of.
Exactly, and the Supreme Court has given valuable guidance, and it will affect conduct of future cases.
Of course, it's different if, as Mr. Baldry says, applying the Supreme Court's guidance correctly understood, the inevitable conclusion is that the objective limb is satisfied.
Yes,
And you say no.
I mean, Yes, I do say no.
Yeah.
How could it be without investigation of the
Well,
kind?
that's
that
right.
the
And that
Supreme Court-
presupposes all the relevant evidence is in the single bundle before us and speaks for itself without the need for any cross-examination.
So even though there might be evidence from the leading tax partners in the Magic Circle firms and the Big Four all saying, well, at the time, nobody thought this was a runner. Because even though that evidence might exist, this single letter is conclusively against us on reasonable discoverability.
I mean, the argument, I think, has to be, well, maybe it isn't quite this, but an argument is the recipient of this advice from Linklaters and the person who has also received in draft the letter that Linklaters is going to send to the revenue would inevitably reach the standard set down by the Supreme Court.
I mean, if I'm to lose on this point,
Yes.
but yeah, that would have to be the way I would lose, but in my respectful submission, that
You
cannot.
don't.
I don't.
Well, there's there may be a subtle distinction, but there are two aspects to your argument, I think, Mr. Grudzinski. There's one that it would not be inevitable if there were other evidence, but there's also the point that there's a fairness point. And speaking for myself only, I'm reminded of what Sir Robert McGarry said in John and Rees, to use my words rather than his, that one should resist the siren call, that the outcome is inevitable, because lawyers are very familiar with the open and shut case that turned out not to be. And that's the whole point about a fair hearing. And even if at the end of the day the result does turn out to be what you thought it was going to be, that doesn't mean that you should simply not have a fair hearing.
Indeed, sir.
Because fairness is a value in its own right.
And at the risk of developing that further, it's part of the rule of law to which all citizens, corporate and individual, rich and small, are entitled to benefit. Can I then just spend a bit more time on the remaining documents? So tab 43, I think Mr. Baldry read out the corresponding passage in the judgment. This is the letter. So there's been a bit of back and forth between this stage and the previous letter, where Linklaters have initially said, well, we'll let you know what we're doing. The Stamp Office say, can you tell us what you're doing? And Linklaters write back at page 203 in the anti-penultimate line saying our client is not at present proceeding with this matter any further. Must have been written on instruction. Tab 51, this is written in March of the following, no, I beg your pardon. Tab 45, this is an advice written by Stephen Posner at Linklaters to Jazztel in June of that year. Further to a conference call we had yesterday, the following sets out the CGT and SDRT issues arising on the issue of warrants. Could anyone please let me know if any of the assumptions set out below are incorrect? And turning over the page after the CGT, SDRT, the issue of the warrants into Euroclear will give rise to an SDRT charge, not subject to developing law on EU compatibility. And then letter C on that page, this liability cannot be sheltered by using the losses referred to above. And then next tab, this is a payment made enclosing a cheque of 393,755 to the revenue from Linklaters. No reservation of rights. This is the letter referred to in the judgment of Roman numeral, paragraph 56, Roman numeral 3. Then, likewise, tab 50, no, no, 51, 13th of March 2001. Next payment, no reservation of rights. Tab 57, same comment. Another payment, no reservation of rights.
Sorry, which tab was that?
57.
Thank you.
In the judgment, paragraph 56, Roman numeral 4, there's a reference to some draft advice from Linklaters in November of 2001 concerning the tax consequences of a buyback of bonds with an associated share issue. The final note of that advice is at tab 61. If you turn to page 261, this is to Jazztel from Linklaters, headed Buyback of Bonds. Following our telephone conversation, this memo summarises the proposal for Jazztel to bring some of its outstanding high-yield bonds within the group so as to reduce its debt. The memorandum summarises our understanding of the commercial drivers and the proposed structures and the tax issues. Tax issue analysis starts over the next page, headed tax issues. And if you turn all the way to page 264, SDRT arising on issue of Jazztel shares to Euroclear or Clearstream or the ADR depository system. You would expect that Jazztel agree under the tender offer to issue its shares to the nominee for Euroclear and Clearstream or the ADR depository so that the shares can be traded on the Nasdaq or Madrid Stock Exchange or in American depository receipt form. If this were the case, there would be a liability to SDRT equal to 1.5% of the market value of the bond repurchased. And then in the same section, second paragraph, in the past where Jazztel has issued new shares under its warrant program and in share-for-share exchanges, Jazztel has paid this liability to SDRT. And then the next documents also mentioned by the judge in paragraph 56 are at tabs 71 and 76. If we just look at 71, this is August 2002. Covering email from Joe Windsor at Linklaters. I attach a note setting out possible solutions to two outstanding tax-related issues. The first relates to the cancellation of, must be loan notes issued by PLC. The second relates to stamp duty payable in connection with the shares and convertible notes to be issued pursuant to the scheme. And then turning forward in the same tab, at page 2887, under the heading The Issues, PLC now has two choices. It can either issue the new shares to an escrow account for onward transmission at a cost of £10 each, or it can issue new shares and convertible bonds to the escrow account for onward transmission into Euroclear at a cost of 1.5%. PLC has historically agreed to pay the stamp duty which would arise. Again, no mention of EU law. And then in the next volume, we have a document mentioned by the judge at 56 Roman 6 in 2002.
Sorry, which tab?
76.
Thank you.
We've received a number of communications from the bondholder communications group concerning the question of whether it is correct and fair that SDRT should be payable on transferring the new shares and bonds into Euro. That's not a mention of EU law, that's just a fairness point. I think the judgment notes that. From our perspective, the law and practice are quite clear on this point. We could, of course, challenge the established position on the basis that the Treasury would not have intended this result. Not, we could, of course, challenge this on the basis that it's contrary to EU law. Although we would not be at all optimistic as to the prospect of such a challenge succeeding. We would, however, only do so if the company and the ad hoc committee consider this an appropriate use of funds. We will therefore take no further action in relation to stamp duty unless we're specifically instructed to do so. This is not a mention of EU law. It's a mention of some fairness challenge that the bondholders had mentioned, and Linklater's advice is, in any event, not at all optimistic.
And it is dealing with the same problem, is it?
Well, it's dealing with the payment of stamp duty and SDRT. It's not clear precisely what problem is being discussed there. But what is clear is there's no mention of EU law, and even if that is what it was discussing, Linklaters are saying we're not optimistic.
Well, it refers to transfers.
Yes, it refers to transfers. Yes.
And Linklaters have always advised that the issue on transfers was different because transfers fall within Article 12.
Although, as we eventually know, in HSBC Vida Cost nominees, transfers were also held to be inconsistent with SDRT.
No, not transfers. There was issues of
Air Berlin.
deposit.
Sorry,
receipts.
Air Berlin. Sorry.
Transfers have always been different. That's what this is concerned about.
Except in Air Berlin, which is part of the same GLO action, learned friends and I successfully argued in the European Court of Justice that it applied there too. Is it being said that we should have predicted that in 2002?
I mean, I'm not sure how far this matters, but potentially this is actually dealing with a different problem.
It may well be. I think on balance, and I think that's how the judge saw it, it is dealing with a different problem.
Yeah.
But whether it is or isn't, Linklaters were not optimistic. So the first time that EU law rears its head again, as it were, is tab 100 in February 2006. So we've gone from September 2002 to February 2006. This is the email at tab 100. Email from Dan Laurie of the Tax Department in Linklaters to Anna Rika at Jazztel. Dear Anna, my colleague Bill Warner has asked me to contact you regarding the Jazztel share allotment to the 9th of February and the amount of SDRT to be paid to HMRC. Late payment might result in additional interest and penalties. The amount is £162,963, and there's the calculation. There's the account details for how to pay. As we have mentioned in the past to your colleagues, there are in fact questions as to the validity of the UK charge to clearing systems under EU law. Given the increase in the number of cases that have recently been brought contesting UK tax law, so I just interposed, that's not a reference to SDRT because there were no cases at that stage in relation to SDRT, at least not in the public knowledge. That could be, I'm inferring, that could be a reference to the dividend litigation, the ACT litigation, everything following from Hearst, etc. Yes,
and this is all the fallout from Herx, wasn't it?
Exactly.
It's really taking off at this point.
Exactly. It is conceivable, the email continues, that the charge to SDRT may be challenged before too long. So the inference is no one's challenged it yet. With this in mind, when we forward your payment to HMRC, we would propose making clear that it's being paid without prejudice to Jazztel's right to contest the validity of the charge at any time in the future.
I mean, I don't know. When it says, as we have mentioned in the past to your colleagues, if they're referring back to 2000, it might be a little coy.
The inference is it's the 1999. There's no other.
There's nothing else in the document.
There was a CPR compliant list of documents produced. Everything relevant was disclosed.
Yeah.
Including, at the risk of stating the obvious, legally privileged advice.
And presumably all privilege was waived.
Must have been.
Must have been, in order for this material to be put before the court.
Yeah. How anyone could resist a collateral waiver argument in those circumstances? No. There's not been cherry picking.
Yeah.
If I were to apply the objectively, and I stress objectively,
yes.
What's your submission as at the date of this email? Could it have been
I literally can't answer that question, my lord, because what we know from this is that no challenge had yet been brought. We don't know whether, if there was I mean, I call it expert evidence. Whether it's expert evidence or evidence, we know that experts can give evidence of fact. And let us say, at a trial, you had evidence from either an expert that's collated all the advice that was being given at the time, possibly quite difficult, or evidence from what were recognised to be 5 leading tax practitioners that said, yes, it was beginning to be recognised at that stage that in general terms, UK primary legislation could be challenged. But at that point, there were no European law cases on the Capital Duties Directive or otherwise that suggested that SDRT would be contrary to it. The generally received, insofar as people were turning their mind to it, the generally received understanding was that such a challenge would fail. I'm just hypothesising what the evidence might be.
Or it might not be, but you say, fundamentally, this was never gone into, and it would be simply unfair to assume what the answers would be.
That's my primary position, and my fallback position is, if it is to be investigated, one can't be put down on the basis of this letter.
This is one of the difficulties to which I think you point, that inevitably, at this level in particular, what we do is we island hop, as it's sometimes been put. We don't see the entirety, as a trial judge would. Sorry to keep going on about fairness, but fairness is a distinct point, I think, from what would actually happen. Sometimes the two are linked, but actually, I think on the whole, we tend to take the view that it's not just important to get the outcome right, but it's important to get the outcome right after a fair hearing.
Indeed so. And just looking at something. I would respectfully agree.
I mean, in practical terms, 2006 no longer matters, does it? Am I being stupid?
No, I think it does, because our High Court claim wasn't issued until 2013. You mean because of period 1B and because we've lost on issue 9B?
You've lost on everything from...
Yes, it would only matter for my client for the purposes...
It would only matter if you could overturn Leeds.
Leeds, exactly. That's what I want to say on the documents. Can I then, before going to FII, deal briefly with the AB decision of the House of the Supreme Court, AB Administrative Defence? The majority in that case were Lord Wilson, Lord Walker, Lord Brown and Lord Mance. So the dissenting minority were Lord Phillips, Baroness Hale and Lord Kerr.
So a 4-3 split.
A 4-3 split. And there's a lot in this, and to some extent it's been consolidated into, and taken into account in the FII decision. But there are a couple of passages I want to take you to, both helpful to me, and I think I'm going to need to deal with one passage that, on the face of it, might be thought at first sight, and I really do mean at first sight, to be unhelpful. The helpful passage is in the judgment of Lord Wilson, at page 94, who gave the first speech, first judgment for the majority. Starting at paragraph 12. What then is the degree of confidence with which a belief should be held, and of the substance which it should carry, before it is to amount to knowledge for the purposes of the subsection? Of course, the subsection here is section 14 of the Limitation Act and section 33. It was, again, Lord Donaldson in Hawford and Brooks, who in the passage quoted from Lord Phillips below offered guidance in this respect, which Lord Nichols in Hayward and Fawcett was to describe as valuable, and upon which at this level of generality no judge has, in my view, yet managed to improve. It is that the belief must be held with sufficient confidence to justify embarking on the preliminary to the issue of a writ, such as submitting a claim to the proposed defendant, taking legal advice and other advice, and collecting evidence. All relevant, as I will come on to say again, to tort fact-based claims. In Broadley and Clapham, Lord Justice Hoffman, in the passage quoted by Lord Phillips, paraphrased Lord Donaldson's guidance in terms of a search for the moment when the claimant knows enough to make it reasonable for him to begin to investigate whether he has a case against the defendant. I respectfully agree with the analysis by Lord Phillips of what Lord Justice Hoffman meant. The investigation upon which the claimant should reasonably embark is into whether in law he has a valid claim. In particular, whether the act or omission of the defendant involves negligence. So he will know of the act or omission. He'll know he's been knocked over. He'll know he's got cancer after working in a radiation facility. He knows he's got mesothelioma after working in an asbestos facility, etc. In particular, whether the act or omission of the defendant involves negligence or other breach of duty, being a matter of which the claimant is not specifically required to have had knowledge under Section 14, and if so, how that claim can be established. So, it's an investigation likely to be conducted with the assistance of lawyers, but in the light of their advice, it may well also embrace a search for evidence, including from experts. The focus is upon the moment when it is reasonable for the claimant to embark upon such an investigation. It is possible that a claimant will take legal advice before his belief is held with sufficient confidence and carries sufficient substance to make it reasonable for him to do so. That's a very important sentence in my submission. Thus, as Lord Justice Judge pointed out in the Schnizek case, it does not automatically follow that by the date when he first took legal advice, the claimant will have acquired the requisite knowledge, but such an inference may well be justified. So you can sometimes infer, again, my pedestrian analogy, someone has been knocked over, or someone has contracted a disease. One might well often be able to infer from the fact that they've gone to see a solicitor, that they've reached the requisite stage. But for reasons I will develop, and that perhaps too obvious to need stating, that's very far from what happened in this case. Just continue. I hasten, however, to attach an obvious rider. From the fact that a claimant may well need to consult experts after he has acquired the requisite knowledge, it in no way follows that he will have acquired such knowledge by the date when he first consults an expert. Section 14 expressly recognises that the facts which he is required to know may be ascertainable by the claimant only after with the help of experts, and deems him to have acquired such knowledge at the point at which he might, with their help, reasonably have been expected to acquire it. In my view, the date on which the claimant first consulted an expert is not on its own likely to assist the court in determining whether by then he had the requisite knowledge. Instead, the court will have regard broadly to the confidence with which the claimant held the belief and to the substance which it carried prior to his consulting the expert, and in particular, no doubt, the reasons which included the claimant to consult him. And also, if the conclusion is that at that prior stage the claimant lacked belief of the requisite character, the effect upon the claimant's belief of his receipt of the expert's report. So applying that by analogy in this case, at all material times until the Linklater's advice, Jazztel had a totally unqualified state of mind. It didn't solicit the advice, so the fact that the advice was given tells you nothing, literally nothing. The fact that the advice was given tells you nothing about whether Jazztel had any confidence in an EU law argument. And the result of the advice, so the judge has found, did not come to meaningfully qualify Jazztel's state of mind. It had no serious doubt at any time until 2009 that the tax was due. And applying, by analogy, Lord Wilson's approach, we are very far indeed from the test, the threshold being met. very briefly, Lord Walker, who, in a passage starting at the foot of page 107, under the heading "The Significance of Legal Advice," having discussed Howard and Fawcett and Holford and Brooks, says at paragraph 54, that's a formidable line of authority, that's the Holford and Brooks line. There is still no clear consensus. Most strikingly in Schniezek, Lord Justice Judge rejected the notion that time automatically starts to run against a client who has taken legal advice, whereas Lord Justice Simon Brown found it difficult indeed to imagine a case where, having consulted a solicitor with a view to making a claim for compensation, the claimant could still then be held to be lacking in the requisite knowledge. I respectfully but unhesitatingly prefer the view of Lord Justice Judge, and then picking it up at the first sentence of 56. So in practice, a claimant's first visit to a solicitor may do no more than initiate the process of obtaining expert medical advice. Can I turn back, however, to a passage that my lords may have picked up already in the speech of Judgment of Lord Wilson?
Just before you do, I'm jumping around myself. Paragraph 58.
Yes.
So Lord Walker says, Schneezek says in practice 3 years may not be enough where the claim for personal injury raises difficult issues of causation. Nevertheless, there is a distinction in principle between a claimant's knowledge, actual or constructive, that he has a real possibility of a claim, and the assembly of material justifying commencement.
I mean, there's some, as I said yesterday, there's some difficulty about applying all this to the current context. In the case of tort-based claims, and indeed mistakes of fact that you can uncover, mistake of fact or fraud or negligence, they are primarily fact and evidence-based causes of action. In a mistake of law restitution claim, the only relevant matter is the payer's state of mind, or what, with reasonable diligence, the payer, from a discoverability point of view, the payer's state of mind ought to be. So if you're being told by your lawyer you haven't got a case that's likely to succeed, and your predominant state of mind in which you have no serious doubt is that the tax is payable, I do submit it is impossible for you to be said to have discovered to the requisite degree of confidence that you have a worthwhile claim.
Getting off briefly at a tangent again, one complication with AB and the Ministry of Defence, or Howard and Fawcett's, or these earlier cases of that kind, is that you're actually dealing with specific statutory provisions.
Which talk about knowledge of facts, knowledge of attributability, knowledge of damage. Section 14 is you've got to have knowledge of damage and knowledge of the attributability of that damage to the acts or omissions of the defendant.
But on the other hand, I think it expressly says you don't have to know that there's legal liability.
No. But in the mistake of law, it's very difficult to separate. It's all about the law.
So there's some potential difficulty when what has been said in the context of that statutory regime is imported.
Well, with respect, I
Section
agree, but
32.
we are where we are.
And then there's a slight other oddity that the other formulation in the Supreme Court is worthwhile claim, which sort of echoes worthwhile cause of action, which had been debated through the 1960s and then rejected.
Indeed, well, the Law Commission report, as I discovered last night, was highly unenthusiastic.
Let's go for it. So we're dealing with one formulation which is derived from a different statutory context, and another formulation which has a prehistory that was then rejected.
Yes. Which is why I focus on what a worthwhile claim can mean, because there is, notwithstanding the tension between those issues, as my lord has identified, indications that when we're talking about a mistake of law in a tax context, you've got to have good grounds for believing that the money was not due.
And then that itself is ambiguous. Good grounds. Is that real possibility? Is that more likely than not?
Well, you have to believe in the, I mean, as I'll show you when we get to the speeches, the judgments in the Supreme Court, you have to believe in the truth of your assertion.
And would you accept you also have to have a case strong enough to withstand the striking out application on the basis that it discloses no cause of action?
Well, I wouldn't say that is the test.
I know it's not, but it's quite a useful rule of thumb. It's always seemed to me, maybe wrongly.
I mean, there are all sorts of tests. Real possibility, strikeout, JR, threshold, permission.
That's the problem. There's a multitude of perfectly plausible seeming candidates.
Thing is, sorry. If Jazztel had brought a claim, I can't see how it could have been struck out.
No. Not least because we all know the law may develop, and the only way we can achieve a development in the law is by starting a case which may or may not.
Yes, I have to say, I think if Jazztel had brought a case in 2000 in restitution,
well, that would be more ambitious.
it would have got, I suspect the revenue might have applied to strike us out. I mean, as is always the case in these appeals, Mr. Baldry said, well, I know all those 25 other arguments of the revenue were wrong as decided by X or Y appellate court. They were obviously always wrong, but the revenue ran them. What a criticism.
And I quite follow. This particular claim, with its restitutionary element, would have been particularly ambitious. But in a sense, the real question is, were you obliged to pay the money? And
I would accept that. But on the face of it, this, I'm sorry to repeat the point, this is primary legislation. This is not some policy guidance from the revenue which is said to be ultra vires. This is Parliament Supreme. And you've got to...
Well, yes, Mr. Grzeski, but in 1995, Herx issued its writ.
I accept that.
And that was referred to the ECJ. See, I suspect, one can only speculate, but in the year 2000, if this issue had been raised, I think it might well have been the subject of reference.
It might have been. Well, it was, I mean, a similar issue was the subject of a reference in 2007 in the HSBC case.
Yes. Yeah. But these cases,
that was 5 years later.
I mean, I'm sure it doesn't matter for our purposes, but the claim was in 2002, wasn't it? I'm not sure what happened.
We didn't know.
No, you didn't know.
HSB, we know.
Well, there's no evidence at all you knew.
Well, there's no evidence that we knew.
But I'm not sure what happened between 2002.
There's no evidence we knew. On the face of it, the Linklaters, there's nothing in the Linklaters to suggest we know that others are bringing similar claims.
well, that may be right, but if the test is an objective one,
It is what's reasonably discoverable, my lord. It can't be, in my submission,
well, the fact that somebody else has brought a claim, why isn't that reasonably?
the fact that what if, I mean, advances in legal understanding are often pioneered by people, whether in the tax context, public law context, or other contexts. And generally those people will take points 8 times out of 10 they'll fail. So, in my respectful submission, the mere fact that one other claimant, similarly situated, has it brought a claim does not necessarily answer the point. What is reasonably discoverable will need to take into account, as the Supreme Court has said, what was the generally prevailing view. I mean, I know we're not in the context of medical negligence. I'm not suggesting it's a Beliveau type test. But it does not follow from the fact, it would not follow from the fact, even if my client had known about the HSBC position, that if ipso facto the reasonable discoverability test has been passed. It might do, depending on what other evidence there is out there.
I mean, to go off on another tangent, I'm not quite clear what the nature of the HSBC dispute was procedurally. Did HSB simply say they weren't paying the money? They won't have issued a writ, presumably.
No, this is all in the special commission.
Yes.
It's an appeal. So,
So an appeal from an assessment?
Can I have a look? I've actually printed out the special commissioner's reference.
I think it would have been a claim under Regulation 14 for repayment of stamp duty reserve tax already paid, the same as the claim articulated by Jazztel.
So they paid and asked for the money back?
in a transaction in 2000.
Yes, I see.
And presumably under the regulations, there's a right of appeal to the special commission.
There is.
Yeah.
I mean, whether bringing an appeal is similar to issuing proceedings in the High Court is another matter for debate.
Mr. Brzezinski, had you finished? I think you were looking up something.
Well, I was looking up to see what the factual background was. I'm going to ask Mr. Jones to have a quick look to answer your question.
Can I take you back, if you left that topic,
Yes.
Can I take you back, please, to paragraph 12 in the judgment in AB,
Yes.
which you read out to us earlier, Lord Wilson's judgment. I'm just speaking for myself. I'm not finding this easy. What's said here easy to follow. You may be able to help. Just between letters G and H.
Yes.
Lord Wilson is summarising what earlier judges have said, and he formulates this point: the investigation upon which the claimant should reasonably embark is into whether, in law, he has a valid claim. So that's clearly contemplating that the time in issue would be well before, for example, issuing a claim. It even appears to be even before taking advice on it, because it's an investigation whether in law you have a valid claim. But I'm not sure how the word investigation really fits into a context like the present anyway.
Well, I agree. I mean, what is there to investigate in the present context, other than what is the strength of my legal argument? European law is inconsistent with sections 93 and 96 of the Finance Act 1986. There are no facts to investigate. There is no evidence to collect.
And we all know, unless it's act clear, that's a question that can only be determined by the European Court.
Which is why DMG was decided as it was.
Yes.
But that's why I said in my summary yesterday that the assistance that one can gain to the concept of collecting evidence drawn from fact-based tort, deceit, mistake claims is, with great respect, I can't say it's nil because that would be inconsistent with what their lordships have said, but it's limited. And as my learned friend Mr. Baldry rightly emphasised yesterday, ultimately the Supreme Court accept that everything depends on the circumstances of the case. They can't be laying down a test for discoverability or reasonable discoverability that applies irrespective of the circumstances of the case and irrespective of the cause of action. I think it's the opening sentence of paragraph 200 and either 110 or 210.
I slightly wonder whether paragraphs 9 to 11 are...
It's 200,
relevant.
before I forget, it's
Yes.
210. In practice, the application of that approach will depend on the circumstances of the case. And then, in a passage I'll come back to, in 211, Lord Reed and Hodge say, thus in the circumstances of the present case, Lord Walker referred in FII to there being a reasonable prospect that the limitation period could be deferred until the time when, quote, a well-advised multinational group based in the UK would have good grounds for supposing it had a valid claim. Again, in my respectful submission, it is quite impossible to conclude that Jazztel had good grounds for supposing it had a valid claim following the Linklater's advice and following the judge's findings of fact based on that advice. I was going to deal with another part.
Just before you do, still with Lord Wilson,
Yes.
paragraphs 9 to 11.
Yes.
Now, the complication is, this is all in the context of the specific statutory regime.
Yes.
But it seems to be being carried over to an extent. So in paragraph 9, Lord Wilson says we shouldn't readily jettison the welter of jurisprudence about the medium of knowledge. Paragraph 10, we see in Halford and Brooks, Lord Donaldson said that reasonable belief would normally suffice.
Although, can I just pause there? Reasonable belief is obviously an objective concept,
Yes.
whereas in our statutory question, namely 33(1)(c), it's not quite put that way. It's either what did they in fact believe, what did they in fact discover, or what could they with reasonable diligence have discovered.
Yes.
So it is slightly different.
Well, let's be so careful here. And reasonable belief is actually a mixed test, isn't it? The existence of the belief is subjective. Whether it's reasonable is objective.
Yes.
But
But that's not...
And neither by itself is enough.
But that's not the test
No.
in section 33(1)(c).
No.
but I mean, belief, whether it's arrived at subjectively or where you would have got objectively, is quite a high test. I mean, this is.
That's my
I know you say this. And if we go on in paragraph 11, between B and C, Lord Wilson says he might have ventured reasoned belief rather than reasonable belief. The word reasoned might even better have conveyed the need for the belief not only to be held with a degree of confidence rather than to be little more than a suspicion, but also to carry a degree of substance. So we see the distinction being drawn between degree of confidence and mere suspicion.
Indeed so. And I mean, suspicion is itself a loaded word. You can suspect that somebody has cheated you. Whether the use of the word suspect is the same when you're thinking, I suspect that there might be an argument of EU law. It's not really a suspicion, because let's face it, the only people who can properly form a view on that are lawyers. So, but if your lawyer is telling you there's an argument here, but we think it's going to fail, you probably don't even have a suspicion that you've got a good ground. You've got no serious doubt that you've got a good ground.
It's a kind of state of mind reflected in when one uses words like speculative, isn't it? You have a speculative claim. In the sense it's not impossible it will succeed, but on any rational forecast it's not at all likely.
I mean, I don't want to get too deep into the weeds here, but as all of my laws will recall, when clients come to you, what you really often want to say is, really tricky, it's 50-50, and clients don't like being told it's 50-50. But sometimes you're in that territory. But Jazztel wasn't in that territory. Jazztel was being told, not it's 50-50, you might well have a good claim, give it a go. Or give it a go if you want to spend enough money on it. Jazztel was being told, as the judge found, it's weak, at least beyond one specific share for acquiring a share in another company, or at least the grounds were weaker than the strong grounds. And well, I'm not going to paraphrase how the judge found that advice impacted upon Jazztel's view.
Right.
It did not inject any serious doubt into their mind. And whether, had Jazztel been prepared to spend the money digging around or asking Linklater to investigate further, it goes back to the fairness point. Can I, because yep. Can I just show my lords a passage that I think I do need to deal with. It's in the judgment of Lord Wilson, at paragraph 3 on page 91, between letter B and C. In my view, it is a legal impossibility for a claimant to lack knowledge of attributability for the purposes of section 14 at a time after the date of the issue of his claim. By that date, he must in law have had knowledge of it. But the reason for that is given in the next sentence. Pursuant to CPR 22.1, he must verify his claim form by a statement that he believes that the facts stated in it are true. The word in the statement of truth is believes rather than knows, only because, of course, the assumption that the cause of action exists does not apply to the claim form. That exists is indeed a claim. And the reason I grapple with that is I don't want it to be said against me that if as a matter of form under the Regulation 14, the Linklater's letter was a claim, it's legally impossible for us at the same time not to have had sufficient confidence, etc. Because there is no, the reason that Lord Wilson draws that conclusion about legal impossibility is because of the import of section of CPR Part 22.
Is that right? I mean, I follow he makes the point about the statement of truth, but then he says, irrespective, however, the degree of significance to be attached to the statement of truth. I haven't read on to work out exactly how that fits in.
Yes, irrespective of the degree of significance to be attached to the statement of truth, it's clear to me that the inquiry mandated by section 14 is retrospective, namely when the claimant first had knowledge of it. That's attributability. That is a factual inquiry.
No, I follow that, but I'm
But I don't think
querying without properly understanding how far Lord Wilson was really worrying about the statement of truth.
Well, but the only point I'm seeking at the moment to address is the legal impossibility point. I think from paragraph 4 onwards, he moves on to analogous or similar issues.
Yeah.
That's all I want to say about AB.
Yep.
I mean, I could spend ages on all the other cases, how the court appointed, but I don't think I'm going to assist the court any further than I have by looking at making my submissions in AB. Can we now turn to the majority judgments in FII? Volume 2, tab 8. I'm anxious to assist the court in whatever way I can. So I'm going to discuss certain passages, but if there are other passages on which the court wants to have my submissions, I'm very anxious to assist. Starting, though, please, with page 380 of the bundle, paragraph 180 of the judgment. This is where Lords Reed and Hodge are discussing the consistency of the approach in DMG with the treatment of fraud as a reason for departing from DMG. As we've explained, Lord Brown dissented in DMG on the view that DMG discovered the mistake when it first became aware of the Hearst proceedings and recognised that there was a serious challenge to the legality of the regime. He stated, I would hold that as soon as a paying party recognises that a worthwhile claim arises, that he should not, after all, have made the payment, and accordingly is entitled to recover it, or as here, to compensate for the loss of its use. He has discovered the mistake within the meaning of section 32. And by the same token, I would hold that if he makes any further payments thereafter, they are not to be regarded as payments made under a mistake of law. Lord Brown thus challenges the fundamental assumption underlying the approach adopted by the majority in DMG, that discovery within the meaning of 32.1 means the ascertainment of the truth, and that a mistake of law is therefore only discoverable when the point of law in question has been authoritatively decided by a final court. On the approach which he adopted, a mistake is discovered when the claimant recognises that a worthwhile claim arises. And as my lord knows, applying that approach, we say it inexorably follows that Jazztel, who did not make a mistake, who beg your pardon, who did make a mistake, as the judge has found, did not discover the mistake until March 2009, because its predominant state of mind was that the payments were lawfully due, and it was in no serious doubt as to that. I think my Lord Justice Newey yesterday suggested to me an argument that if my submission were correct, then the Supreme Court must have been wasting, or might have been wasting its time. And I think I checked the transcript last night. I think what you said is it must be possible to have a state of mind such that you are making a mistake, and at the same time to have discovered enough for you to be shut out. I think what my Lord might have meant was and at the same time to have discovered enough of time to start running for you to eventually be shut out.
Yes.
And we have several answers to that. I.e. to why my submission does not make the Supreme Court's judgment a waste of time. The first is that the most important principle decided by the majority, which fundamentally altered the previous understanding of the law in DMG, is that you can discover a mistake before the point in time when the relevant issue of law has been authoritatively decided by a final appellate court or the Court of Justice. That is the big change, and that is entirely consistent with what I have submitted. Second, as my Lord, Lord Justice Newey, also observed yesterday, in seeking to answer, at least in part, his own question, the position can, in some cases, evolve, and does evolve with the passage of time. Can I just illustrate that, please? One can consider a situation where on the day a taxpayer makes a payment, he is in no doubt at all that the payment is due as a matter of law. Indeed, that is the position for the period covered by what the judge in our case called period 1, up to the Linklater's advice. Mr. Baldry doesn't suggest that in that period the mistake had been discovered or could with reasonable diligence have been discovered. The position can then evolve. You can then be given some advice that identifies that an argument might exist, injects some degree of doubt or questioning into your mind, but your predominant overwhelming belief is that the tax is lawfully due. At that point, when you pay the tax, you don't believe you're making a mistake, but you're told, or you find out years later that you did make a mistake and you bring your claim. But likewise, you have not, in that situation, reached the point of having discovered your mistake. To use the language of the court, you have not recognized, or you do not believe, that you have a worthwhile claim to recover your money. You don't believe you have good grounds. That's obviously the subjective limb. And unless evidence were to show on the objective limb that a reasonably diligent person who had investigated the matter further at that time would have been advised that it did have good grounds, the objective limb will not be satisfied either. Then time passes. Other legal developments take place. You are told by your lawyers that there has been an opinion of the Advocate General in another case, which might be similar to your case, might not be, but which you are being advised by your solicitors tends to support the argument that they had identified sometime previously. And, or, you find out that another taxpayer has issued a High Court claim seeking restitution in materially similar circumstances to yours. By that point, whatever your subjective state of mind, the mistake of law will probably have been discoverable with reasonable diligence. Not inevitably, it will all depend on the evidence, but that may well be the outcome. I've already made my submissions, however, why, on the fact of this case, the subjective limb was not satisfied, and we don't know, and it's too late for the revenue to run, the objective limb. I've written myself some notes about why the letter doesn't amount to the objective evidence. I think I'd just be repeating myself if I read them out. Can I just check that there isn't a point in here that I didn't make to you already? No, there isn't.
I mean, the coexistence point in pure form, and I know you'll develop this anyway, from what you were telling us by way of summary yesterday is you can make a mistake if you think there's a 51% chance of the tax being due. But if you think there is a 49% chance of the tax not being due, will that mean that time starts to run?
I would reserve my position. I've thought about that. I'm not going to concede that point, my lord, because it's very subtle. If your lawyers are telling you, I mean, it's always a bit artificial because percentages are so unreal in the world.
It's a kind of false aura of scientific exactitude.
Indeed.
What really
This
isn't,
is
or
not
something that's
subject to
susceptible
empirical-
to that kind of analysis.
No.
Seems to me.
No.
I know people like it because it sounds scientific.
Yeah, and they can report to their board, well, this is what our lawyer, but that's not in reality how it works. So I reserve my position as to whether anything better than 50% insofar as it has a scientific or legal validity would be enough. There might, notwithstanding, without prejudice or that reservation, be a penumbra in the middle. It's sort of it's arguable and it's not clear, but you've got a good chance here. The candid advice from the lawyer is law is very difficult to predict. It sometimes depends, I'm sorry to say this, on which judge you get on the day. All sorts of factors. How well another case that's before you is going to be argued in the relevant court, etc. So I know I'm sitting here as your expert, you say to your client, but it's really hard to predict. But it's certainly, you can't say you're going to lose this case. You've got a worthwhile claim. I mean, it's very inexact, but on the fact of this case,
You say we don't get to
we're nowhere near that penumbra. Can I return to the judgments? Paragraph 181. Lord Brown noted that DMG had continued to make payments of ACT after July 95 when they learned that Hurst had issued proceedings and that they had issued their own claims 5 months prior to the decision of the Court of Justice. Years later, referring to Lord Hope's statement that when DMG paid the ACT, it was not then obvious that the payments might not be due. Lord Brown commented that he had some difficulty with that conclusion. Surely, said Lord Brown, when DMG learned in July 95 that there was a serious legal challenge to the legality of the regime, it must then have been obvious to them that these payments might not after all be due. Of course, they couldn't be sure, and of course nothing short of a final judgment from the Court of Justice would have persuaded the Revenue to accept any claim for group relief. But it doesn't seem to me to follow that DMG paid under a mistake of law. But again, the risk of saying the same things I have already, we're a million miles from that. We weren't in 1999 or 2000 in a situation where we knew that somebody else similarly situated had issued proceedings.
I mean, on the other hand, serious legal challenge might not suggest a lower threshold than some of the other passages one might point to.
There is not complete consistency between the passages. Sometimes it's reasonable case, sometimes it's good grounds, sometimes the umbrella term is worthwhile claim. But whatever the level within that range, we don't even hit the bottom.
Yeah.
Mr. Grzelski, correct me if I'm wrong, but I don't understand the majority in FII as necessarily agreeing with Lord Brown. Because, as my Lord said yesterday, Lord Brown Lord Brown's analysis has the conceptual attraction that essentially he equates mistake of law with whatever this test is under the Limitation Act. But my understanding is the FII majority judgment doesn't go that far. It recognises that there may be a distinction in point of time between the mistake. Obviously, the mistake occurred when the payment was made.
Well, it certainly recognises a distinction between the point in... I mean, can I answer that question in due course? It's not altogether... I'm not sure, with respect, there's an altogether clear answer to the extent to which they do or do not adopt what Lord Brown has said here.
Speaking for myself, and this may be very crude indeed, which is why I want you to have the opportunity to tell me why it's simply wrong. The first sentence of Lord Brown's quotation there, in the middle of that page, against letter D, I see a lot of force in that point. That if somebody else was able actually to bring a claim, that they actually issued the writ. So it's not that they've just gone and taken advice or whatever. They've actually had enough confidence to issue a writ.
But what if they're a vexatious litigant, my lord? Well, I mean, as my lord rightly observed yesterday, tax cases can, in theory, be brought by the chippy, the small, medium enterprise, and the large, well-advised corporation. What if you found out that some person who used to be a vexatious litigant but has a particular vendetta against the revenue and thought everything was answered by European law, had issued proceedings in the High Court saying...
Well, I think that's why Lord Brown uses the word serious. It's Herxt. It's not a vexatious litigant.
Okay, but just pause there for a second. I don't know who Hearst was advised by. Maybe they were advised by a pioneering law firm. Maybe, hypothetically, the predominant view of the Magic Circle firms and the Big Four, and indeed pretty much everybody, was that's good on them, but that's never going to succeed. Would the reasonable diligence test have been satisfied? In my submission, it would not.
This is really coming back to your fundamental submission, that in this area, one has to be very careful to say, well, there's this event, and that's conclusive of the objective limb. You say, I'm not saying I agree with you, but you say that fundamentally the objective limb in this context of mistake of law would require potentially evidence to be gone into, which might include experts coming along and saying what the evolving state of legal thinking was at a given point in time.
My lord gives me a second. Paragraph 255 of the judgment. This court cannot determine in the abstract the point in time when the test claimants could with reasonable diligence have discovered to the standard of knowing that they had a worthwhile claim, that they paid tax under a mistaken understanding they were liable to do so. That depends on an examination of the evidence. As we've explained, EU law in relation to tax regimes which discriminated between companies based in one member state was evolving. And there's a previous passage, I think it's 211. Yes, I thought it was 211, but I looked at it and I couldn't find it. Yes, paragraph 211. Clearly, where a payment was made in accordance with the law as it was then understood to be, which is our case, the point in time at which the claimant could with reasonable diligence have discovered that the basis of the payment was legally questionable so as to give rise to a worthwhile claim would have to be established by evidence. The focus is likely to be upon development and legal understanding within the relevant category of claimant and their advisors.
Yes, well, it won't surprise you to learn that I'd flagged that passage.
The legally questionable. I mean, we get that
It's
formulation
good.
too.
I said on the face of it, legally questionable might be thought to sound a bit different from good ground. But I come back to, or at least on the subjective question, you've got to believe in the truth of your assertion. Merely knowing that there is a question to be asked, in my submission, can't be enough. if your view remains that the tax is clearly, undoubtedly due. What does legally questionable mean?
And the whole of this discussion rather reinforces the point I was perhaps making yesterday. I mean, this is opening up vistas of massive satellite litigation, immensely complicated and difficult hearings, dealing with the precise point at which...
I was going to say. That is, with respect, exactly what the minority said. I mean, my lords know that Lord Sales and Briggs dissented.
Yeah.
They dissented in a way that would have been even more catastrophic, as it were, because their solution was that Claimant Benson was wrongly decided.
Yes, that was the root and branch solution to the whole problem.
But part of their reasoning was precisely the one that my lord had just identified.
I mean, the more we have this debate, very interesting it's been, but I mean, always still is. It seems to add fuel to that worry. But plainly, the majority, majority plainly had that well in mind, because I mean,
they must have done. I mean,
they talk about the expert evidence apparently without it causing them any pause for thought.
And I don't know much about what goes on behind the scenes in the Supreme Court, but they will have read in draft at least the dissenting judgment of Lord Briggs and Sales, which at paragraph 298 sub 3 says the test of discoverability proposed by Lord Brown is very uncertain.
Yes. And indeed, as was the way in which the landscape changed through all those decisions in the European Court, culminating in Hertz. If we have to go back through all that again, I mean, it's even with the benefit of hindsight.
Well, that's what they say. They say at letter G on page 421 of the bundle, the application of the test will often require a wide-ranging investigation at trial of something as inherently vague and intangible as the state of professional opinion as it changes year by year over what may be a very long period. It's unclear whether expert evidence would be of much of assistance for such a speculative investigation into legal history. Moreover, the more one focuses on what was reasonable to expect of one claimant, or particular type of claimant, as distinct from the general understanding of the legal profession, the greater the range of cases in which the court will have to produce speculative and uncertain judgments as to whether the reasonable threshold of discoverability has been passed. And they thought that couldn't have been what Parliament intended, but that's what the majority has decided, unless we have another go.
As you say, hindsight can be a wonderful thing in this area. It has struck me, you don't have to comment on this, but it has struck me over my legal career that points that were run that were thought to be, well, quite frankly, hopeless.
That's my point.
Eventually prevailed in the House of Lords, and then I couldn't find any lawyer who disagreed.
Yeah, I respectfully have had, I agree.
And of course, getting an answer from the final Court of Appeal isn't necessarily determinative. I don't know if the revenue can make claims to recover all the sums they've paid out, not knowing that FII would reverse.
Well, I did wonder about that. I did wonder about it. What the consequences of it. I mean, there is, on many view, years of litigation ahead. What? Yeah, well, as Mr. Jones says, there'd be limitation problems for the revenue. And change of position problems, no doubt. It's arrested anyway, whatever. Can we go back a few pages in the judgment? Again, unclear to what extent this then informs the test later on, but at paragraph 182, we see citation from Lord Brown's consideration of the parallel treatment and the deliberate concealment and fraud and mistake of fact case. Once a plaintiff recognises that he has a worthwhile case on the facts to pursue a claim in fraud, or to extend the limitation period for a particular claim because of deliberate concealment, time surely starts to run against him under section 32. He couldn't successfully argue that time starts running only from when the court eventually comes to reject the defendant's denial. Well, of course that's right. Of course that's right. But that's not. There's very little analogy that can be drawn between that context and the present. But perhaps more relevantly, the view expressed in that passage is supported by a number of authorities concerned with the application Section 32 in cases of fraud. The first, which might be mentioned, is the judgment of Lady Justice Arden in Biggs and Sotnick's. In deciding whether the appellants could with reasonable diligence have discovered a fraud, her ladyship treated the relevant date as the correct date when the appellant's solicitors had sufficient information in their hand for the purpose of this deceit claim. That is to say, when the appellants were in a position to plead their own case, that's the pleading of the test case. And then there's a discussion of the fraud approach, and then there's a conclusion at 186. What's more important, however, is the approach adopted in these cases of fraud, like that proposed by Lord Brown in the cases of mistake, treats the relevant date not at the date when the claimant knows or can establish the truth, because that can only be known for sure at the end of the appellate chain, but the date when he can recognise that a worthwhile claim arises, or, in Lord Brown's formulation, can plead a statement of claim. But all of that, whether we're talking about fraud, mistake, CPR compliant or not CPR compliant, you've got to believe in the truth of your case. Then can I move forward to a passage that starts at 190, where Lords Reed and Hodge refer to AB and Ministry of Defence and to the Hayward and Fawcett's test that we've already looked at. And they say in 191 that that formulation places the commencement of the limitation period slightly earlier than the fraud cases discussed. The relevant time is, well, we've seen the formulation. They say that the formulation in Halford and Brooks, etc., is consistent with the way in which the point was expressed by Lord Brown in DMG. It is also consistent with principle. The limitation period is normally postponed, normally begins to run on the date when the cause of action accrues. It's not postponed until the claimant has consulted a solicitor. Then we get the pedestrian example. A pedestrian who is knocked down and injured by a car while using a zebra crossing has a cause of action which accrues on the date of the accident. It will take time before he can issue the claim. He'll need to consult solicitors. And counsel maybe have to be instructed to draft the claim. There may be many matters which have to be investigated. And it may be that his claim will fail in the end if it's found that he suddenly ran into the path of the car, but the driver had a heart attack. Nevertheless, the limitation period begins to run on the date of the accident. It's not postponed until he's completed his investigations, or until he knows that his claim is guaranteed to succeed. But I'm not suggesting that we had to know that our claim was guaranteed to succeed. I'm suggesting something had to have happened for us to know that we had a worthwhile claim. And on the findings of the judge, that did not happen.
And anyway, as you've already been submitting to us, a personal injury analogy is not really particularly helpful in the type of case we're dealing with.
No.
It's a mistake of law of a really theological nature, very often, which can only ultimately be resolved in Luxembourg.
Indeed, and even more so, you're not, I'm sorry to make the opposite, you're knocked over by a car. You know, irrespective of what people sometimes rather rudely call the blame culture, it's pretty obvious that you've got something to complain about. It is not obvious that primary legislation enacted by Parliament in this context is wrong. Can I then look at paragraph 196? Again, I'm not skipping over intentionally, and if there's anything in the intervening passages, I'm happy to answer it. But, 196. Only the former line of authority, that's the Hayward and Fawcett AB Ministry of Defence line, and the dissenting approach in DMG, as opposed to the majority approach, is consistent with the rationale of limitation periods. It's in the nature of litigation that fact and law are commonly disputed. It's the function of the court to resolve those disputes. Until the courts have done so, the party can at best have only a reasonable belief that their assertions are correct. If a limitation period is to serve its purpose, it is fixing a time within which the claims must be brought. It can therefore only be concerned with beliefs and not with the truth established by judicial decisions. Well, I would accept that. I have to. This is reflected in Lord Donaldson's statement in Halford and Brooks that reasonable belief will normally suffice. Whether that injects a degree of objectivity into the subjective limb is a matter that might need unpacking. But again, all I have to do for my client is to show why on that test I succeed. In light of the judge's findings of fact, my client did not have a reasonable belief that the tax was unlawful. Quite the contrary, had no serious doubt that it was lawful. I'm now going straight on in page 390 of the bundle. This is under the heading The Practicality of the Suggested Approach. And I emphasize the first sentence of paragraph 210. In practice, the application of the approach will depend on the circumstances of the case. For example, in cases where the claimant has made a payment on the basis of a mistaken understanding of the law which has resulted from ignorance, the mistake will normally have been discoverable immediately by seeking legal advice. Well, Mr. Baldry fairly accepted that this is not an ignorance case. Section 32 only has effect where a mistake could not have been discovered at the time of the payment with the exercise of reasonable diligence. Maybe that's what my Lord Justice Newey was perhaps putting to me. On the other hand, where the payment was made in reliance on a precedent that was subsequently overruled, or an understanding of the law that was later altered by a judicial decision, that is our case. The question will be whether the claim was brought within the prescribed period, beginning on the date when it was discoverable by the exercise of reasonable diligence. So that we're now in the objective, not the subjective limb. But the basis of the payment was legally questionable, so as to give rise to a worthwhile claim. Paragraph 211. Clearly, where a payment was made in accordance with the law as it was then understood to be, that's our case. The point in time at which the claimant could, with reasonable diligence, have discovered, this is the passage I read out to you earlier, the mistake of the payment was legally questionable, will have to be established by evidence. And I've read all this out. And then there's the approval, importantly at letter C. Thus, in the circumstances of the present case, Lord Walker referred in FII to there being a reasonable prospect that time begins to run when a well-advised multinational group would have had good grounds. So on the specific facts of FII, namely, you pay you pay money in accordance with national legislation. Sometime later, the judgment shows authoritatively that that payment was made in accordance with legislation that was incompatible with EU law. In that specific circumstance, the point is reached when, on the objective limb, when your well-advised multinational group would have good grounds for supposing it had a valid claim. And you may well need expert evidence for that. My lords have seen all the recapitulations in paragraph 213. I'm not sure they add anything to what I've said already. I fear that if I said anything further, I'd just be repeating myself. And my lords have the essence of our submission. Unless I can assist further, that's what I want to say.
Thank you very much, Mr. Krasinski. Mr. Baldry.
Do you want the lectern?
Yes, please. Okay. Thank you. My Lord, may I begin with section 320, and in particular the issue, or the mainstay of Malone and Friends' case, that Fleming has really answered the issue in this case. In my submission, Fleming has not decided the issue in this case. The issues that were being discussed in Fleming and the reasoning of the court was all concerned with not simply a different argument relating to the same issue, but with a different issue. And that arises from the distinction between what might be termed a true transitional period and a period of disapplication. And my Lord, Sir Launcelot Henderson pointed out yesterday the passage from Lord Justice Lewison in the Leeds case, where he articulated that distinction. And it is absolutely fundamental to the difference in the issues between this case and Fleming, because what the Revenue were contending in Fleming was that, and what the issue before the court was whether the court could retrospectively read in a transitional period into legislation which didn't have one, and the effect of reading in the transitional period was to introduce, in effect, a new judge-made limitation period into the legislation, which could then be applied against those categories of taxpayer whose EU law rights had been infringed by the introduction of Section 320, namely those taxpayers whose claims went up in a puff of smoke, and those taxpayers who were left with inadequate time in which to bring their claim because of the introduction of Regulation 29(1)(a). So if the court read in the transitional period into the legislation as the Revenue were seeking, and the only question is which length of time it should be, that would create the new time limit against which the affected categories of claimant would all have to bring their claim, and could be used against them even though they weren't aware of this new time limit when it came into force. So that is a process of judicial, the exercise of judicial function to bring in to the law a period by which people have to make their claims. And the Revenue said, once you've read that in, it's the law, and therefore it doesn't matter that people weren't aware about it. That's just time limits. We can use this new judge-made time limit, the end of the period of disapplication, to say that all those people that claimed went up in a puff of smoke, and all those people who woke up on 1st of May and didn't think they had enough time, would lose their right at the end of this judge-made time limit. That was Fleming. But in the present case, the issue is completely different. It has a completely different character. The issue for the court is whether the national court is entitled or required to disapply for an adequate period a new fixed in advance limitation period can the national court disapply that new statutory limitation period against taxpayers who are not in the category of persons who are adversely affected by the change in the law. The new limitation period introduced by Section 320 is not a judge-made limitation period which can be used against those people who had their rights taken away, or against those people who had insufficient time, because the effect of a period of disapplication will enable all such people to bring claims. This case is concerned with, can the United Kingdom rely on the national law for the new fixed period against taxpayers whose EU law rights are not affected, who have not had their rights taken away and have not been placed in the position where they have had to bring claims in such a fixed period of time that they were placed in a position of uncertainty. So,
why do you say their EU rights are not affected?
Because what the principle of effectiveness requires is that taxpayers should be given a reasonable opportunity to bring their claims if there has been a change of the law, and the category of taxpayers who the revenue would seek to apply this new fixed in advance time period would be taxpayers who will have had a reasonable period of time to bring their claims, because these are people who by definition would have seen the legislation on the 1st of May 1997, looked at the new legislation and said, well, I have a reasonable amount of time to bring my claim in that, because my claim was made in such a time that I have 3 years in Jazztel's case to bring my claim. So the revenue isn't using the new statutory time limit to take away people's rights. It's using the new time limit as a prospective time limit, which is fixed in advance for the category of claimants who are entitled to do that. So the court is not being asked to read in a legislative provision which erects an effective new time limit, which is used against the taxpayers. It's reading in an adequate transitional period, which protects anyone who's got an EU law right, anyone who has been retroactively deprived of their their rights. And any person who has been given inadequate time to bring their claim is given an adequate time.
And what does the revenue say is that reasonable time in this context?
It certainly lies within the 6 months to 1 year parameter outlined by Lord Newberg.
The difficulty with that submission may be that what Mr. Grudzinski says is that the fact that, well, there are two problems, I think he says. First, that 6 months to 1 year point has not been publicly promulgated by anyone. And secondly, to give a range means that there isn't sufficient legal certainty. What the whole virtue of limitation periods is, everyone knows where they stand. I've got to get my writ in by midnight on such and such a date. It's 12 months, it's 3 months, it's 6 years, whatever it is. It is precisely formulated and it's pronounced in advance. He says that's the fundamental defect here, that people still are going to have to guess on an ad hoc basis, and the courts will have to determine retrospectively, well, on the facts of this case, did Jazztel have a reasonable period? Some other taxpayer comes along next week and no, they didn't have a reasonable period.
But the period for Jazztel is not fixed by the adequate transitional period. The period is fixed by Section 5 of the Limitation Act, 1980. So Jazztel knows.
Well, no, only if you make the assumption that their case falls outside a reasonable period. Somebody else will come along next week and say, I know you said in Jazztel's case they did have a reasonable period. I had considerably less than that, so I'm going to argue that I didn't. And this is the vice, Mr. Grudzinski says, that you haven't got legal certainty in either of the two senses of precision and public promulgation.
But my point is that if you do have legal certainty because you know what your limitation period is, then anyone who's adversely affected by the lack of legal certainty is protected by the adequate transitional period that the court reads in.
Yes.
And that it's what the court isn't doing, which the House of Lords balked at
No, I understand that.
in Claimant was elevating this transitional period. So this court can say, well, 12 months, if the court feels confident that that is sufficient to protect.
But I'm sorry, I'm still not understanding why this isn't directly covered by the ratio of Fleming. I mean, surely this is precisely the kind of argument that was run and rejected by the majority in Fleming, is it not?
I would say not, because what's clear from Fleming is that all the concerns that each of the majority had, with perhaps the exception of Lord Scott, was to do with the effect of this new time limit, which was being read into the legislation, which took away, which was being used against the very class category of persons who did not have the benefit of the time limit because it wasn't in the legislation.
But why is the present case not also one in which a pre-existing time limit was curtailed? Because previously you had 6 years with the Section 32(1)(c) extension, and now the extension is removed with no advance notice by the ministerial announcement and the backdated effect of the new legislation.
It was curtailed, and
you accept that, therefore, there have to be transitional provisions, but you're saying you only need them for a certain category of those potentially affected. But that's precisely the point in Fleming.
no, because I'm not asking the court to read in a transitional period into the legislation which has the effect of imposing a new time limit. I'm asking the court to say, well, for all those claimants that had a reasonable perspective of time, was that a breach of EU law so that after a reasonable time, the fixed in advance prospective time limit can be utilised? And that's the approach that we say, which says, yes, that's up to the member state in Grundig paragraph 41. And if we go to look at, I'll take you to the reasons. The reasoning in the judgments in Fleming, they're all concerned with this point that what the court was being asked to do was read in a transitional period to offend the very people whose rights were being affected, and that included both the persons whose rights went up in a puff of smoke and those other persons who just didn't know what their position was. But the time limit I'm relying on is the one that's in the national legislation. So it does fall within the sort of category of case ICI Colmer, where you're saying, well, do we strike down this national legislation completely, or can we identify a category of taxpayers whose directly enforceable EU law rights have been infringed, in which case they must be protected, and can we identify another category of taxpayers whose directly enforceable EU law rights have not been infringed because there has been no imposition of by which they have either had their position made practically impossible or excessively difficult, or they have not been placed in a position where the legal certainty of the new regime affects them, because the time limit has been fixed plainly in advance, whereas the taxpayers in Fleming were taken outside that because the new time limit wasn't there until after the event, and then the revenue said, hooray, now we can apply it against you. And what the Lordship said was, no, that's a matter for Parliament. But this is not a matter for Parliament, this is a matter of the duty of the court to disapply national legislation insofar as it takes away or disturbs the rights that should be enjoyed by citizens under EU law. So it is a completely different issue. When we go through the judgments in Fleming, what's clear is that they're all saying, well, yes, this new legislation is doing, it has this effect on the people who it should be protecting. We can't have that. We can't have that. So none of the revenues alternative disapplication periods were effective because they all applied across the board to everybody, whether you had rights that were taken away immediately or whether you didn't. So they were all defective, and the result of that was that the House of Lords said, we can't do what you're asking us to do, but they expressly said, both Lord Hope and Lord Newberg, they said, well, we're not determining the case for every other situation. We anticipate that other courts may reach different conclusions and may read in adequate transitional provisions in other cases, but we say this is such a case.
I suspect that's a convenient moment.
Yes, I'll take you to the judgment.
Yes. So 2 o'clock.
Court rise.